In 2010, Alex was working for a car dealership, and his job was to open up the dealership in the morning and put the vehicles away. In about the third week when he was there, they brought in motorcycles. He was not experienced with motorcycles, but at the end of the day, they would ask him, put those motorcycles away. And as he was doing that, the motorcycle took off on him. And when it took off on him, he went head on into the wall. He couldn't stop the bike. When that happened, the motorcycle just shattered into pieces, and the kickstand of the motorcycle ended up going into his rectum, and that caused paralysis from the waist down.
We tried to contact different attorneys, and nobody wanted to take my case.
It was a case that we almost did not take, only because of the evidence that the defense could introduce in trial, which was the blood evidence. And that was taken at the hospital, and it showed that he had a very high level of meth in his system.
The way it works in workers' comp, if you test dirty and you end up getting injured, the insurance company will not cover. That's standard. The cases are denied. I wasn't afraid of this case because I had the knowledge of toxicology and pharmacology to establish the levels of intoxication and whether or not he was impaired at the time. We obtained an AME doctor to look at the incident and say he was not impaired, and therefore the impairment did not cause the injury.
Dr. Stewart found that our client was impaired due to intoxication. That means that we basically lost the case. Dr. Stewart said if we found an expert that has a difference of opinion, that he may be willing to change his opinion.
The first expert was an internist with a specialty in toxicology, but he lacked pharmacology. This new expert had both toxicology and pharmacology. He made the determination that Alex was not impaired at the time, and what caused the accident was really his inexperience. In trial, there was 3 issues. So the very first issue was chain of custody.
So when Angel sat the police officer down and started questioning him, he didn't know anything about how it was collected. He didn't know what happened to the sample after it was placed in the refrigerator at his office. If they can't provide chain of custody, then the case is won. They've lost.
One of the big issues is they're saying that he was not supposed to be touching these motorcycles. It wasn't his duty to put these motorcycles away. That was all a lie. Lucky for us, some of the management said no. We never had rules. We would just, tell the salespeople, put them away, and they would do it. Judge Lee sided in our favor. She basically said that there was not enough evidence to show that he was impaired, and therefore what caused his injury was his inexperience. From there, it went into the Court of Appeals. The Court of Appeals came back and said, you know what, the trial judge got it right. And from there, the insurance company took it to the California Supreme Court. And in the California Supreme Court, they just came back and said, the petition of the defendants is completely denied, in one sentence, and that was the end of the case. The case settled for 7 figures, which is confidential to disclose. Now Alex, after going through 11, 12 years of this, he finally got justice.
It was fantastic to see that result for the client after what he endured. It's one of those feelings as an attorney where you feel, wow, we did the right thing here. We did a great job for a client.
For us, getting a new AME was monumental. This new AME came in our favor. That was huge in our case. In all the years that I've done these type of cases in workers' comp, I had never done that before. Very rare, and you'll see this, that a case will go to the Court of Appeals. Extremely rare that it'll go all the way to the California Supreme Court.
That's a testament to Angel. Angel looks out for the little guy.
They took the challenge. It was a very tough case. They never give up on me. They never give up on my case.